The inquiry into the fitness to hold office of Advocate Andrew Chauke was established by the President of the Republic of South Africa. The President appointed Justice Nkabinde, retired Justice of the Constitutional Court, as a chairperson of the inquiry, assisted by panel members Advocate Elizabeth Baloyi Mere, SC, and attorney Mashigo Ramagaga. It was supposed to be a straightforward affair, but over the past couple of weeks, the Nkabinde inquiry has transformed into something else entirely. It has become a public, bruising, and deeply personal examination of the examiner herself, and it culminated into a moment that shook South Africa's legal establishment. The National Director of Public Prosecution, Advocate Shamila Batohi, walked out. Welcome to another episode of the Civic Interest Sentinel. Today, we are not simply focusing on the walkout. We are tracing the path that led there. A path marked by disputed competence, a defense of high-level leadership, and an increasingly hostile engagement between the witness and the panel. Many will focus on what Advocate Batohi did not know. But to understand why she left, we must examine how she was questioned and what that questioning revealed. Advocate Batohi's testimony revealed a consistent pattern, distance from operational details. First, the unread docket and the missing emails. At the center of the inquiry is the prosecution of the former Hawks provincial head, General Johan Bruising. Advocate Batohi recommended action against Advocate Chauke for his decision to prosecute Bruising, asserting that there was insufficient evidence. Yet, under cross-examination, she confirmed that she had not personally read the docket on which the prosecution was based. Her explanation was clear. The NDPP operates at a high level and relies on summaries, reports, and advice from subordinates. More troubling was her evidence concerning an email sent directly to her inbox, alleging witness intimidation and threats linked to Bruising. Batohi testified that she did not read the email, believing the matter would be handled by a deputy who was copied. When pressed on what steps she took to protect a threatened whistleblower, her answer was stuck. Open quote, "I cannot recall what exactly happened at the time." Close quote. For the head of the prosecuting authority, this was a moment that resonated far beyond the room. Second, the shifting terms of reference. Advocate Batohi authored the letter to the President that triggered this very inquiry. However, during cross-examination, Advocate Nkabinde pointed to a material discrepancy. A key allegation included in her original draft did not appear in the final gazetted terms of reference. Confronted with this, Batohi described it as an oversight, even sloppiness in drafting. Nkabinde went further, suggesting that the inquiry itself was being used to correct her own errors. The implication was devastating, that the process was not merely examining Chauke's fitness, but repairing flaws in the NDPP's own decision making. Third, the refrain of uncertainty, open brackets, I don't know, close brackets. That phrase became a refrain. Ask whether there was additional facts supporting her case against Chauke. Batohi replied, open quote, I don't know for now if there are any other facts, close quote. When the panel members pointed out missing documents in her submission, she again attributed this to oversight by her team. These answers were not isolated. They accumulated, and in the forum meant to test precision, memory, and decisiveness, the effect was profound. When the inquiry resumed after lunch on December 15, 2025, Advocate Batohi did not return to the witness stand. She was eventually fetched at the direction of the chairperson. What followed was not a procedural exchange. It was a confrontation.
I suppose he had no choice. I don't know.
If I put it that way, is that how you answer?
I don't know if he had a choice or not, Chairperson.
You told him to tell us. Not so.
Chairperson, I will not be shouted at here. I'm trying really to help.
You have been totally disrespectful to everybody.
Well, I apologize then,
and
Chairperson.
we have been so patient with you, disrespecting almost everybody. And this has gone into the record. We've been so patient with you.
It's not the sense I get, but it's fine.
Well, the record will speak for itself.
The panel's position was clear. Leaving without permission while under cross-examination amounted to disrespect for the authority of the inquiry she herself has initiated. Could the panel have paused proceedings to allow her to secure counsel? Possibly, yes. My own view is that insisting that she return immediately poured water onto an already burning fire. If you want an omelette, you must be prepared to break the eggs. But listen again to Batohi's words. I will not be shouted at here. This was not only about process. It was a breaking point. To see this as merely a competent professional facing tough question is missing the deeper layer. From the outset, two critical procedural issues were handled with visible tension. In respect to whether Batohi would complete her testimony in one sitting, and two, whether she would be subjected to cross-examination at all. That tension intensified during a prolonged questioning by panel member Mashego Ramagaga. At times, Advocate Batohi appeared, for all intents and purposes, as if she was the accused. I say this carefully and with empathy. I understand her sense of grievance. Panel member Elizabeth Baloyi Mere's questioning was particularly pointed. Referring to unread email, she asked, open quote, can you enlighten us on the type of work the NDPP does that keep her so busy she cannot read emails? close quote. The subtext was unmistakable, a challenge not just to judgment, but to work ethic and competence. Watching the proceedings, one cannot escape the impression that it was Batohi's own fitness to hold office that was under interrogation. This went beyond robust examination. It veered into a normalization of professional humiliation, where tone, posture, and implication carry as much force as the questions themselves. So, what does this all mean? The inquiry has exposed two intertwined crises. The first, a personal crisis of credibility. Advocate Batohi's public record is now marked by the phrases that resonated painfully. Phrases like, I did not read, or I cannot recall, or I don't remember, or I am not sure, or I don't have that report, or I can assume. For a public desperate for accountability from NPA, this is devastating. The walkout, regardless of provocation, is seen by many as a failure of accountability by the country's top prosecutor. Second, an institutional crisis of the NPA. This personal drama cannot be separated from NPA's broader failure. Batohi inherited an institution desperately hollowed out during the state capture. Yet, under her leadership, no major state capture figure have been successfully prosecuted. High-profile efforts from failed extradition to collapsed prosecution have reinforced public's skepticism. She has alleged infiltration and sabotage within NPA. But those claims have attracted more doubt than decisive investigation. Here lies the irony of the Nkabinde inquiry. The hostility Batohi faces in that room may mirror the invisible hostility she claims has crippled the NPA from within. She was accused of being distant from the detail. Her defense is that she is fighting a far larger institutional battle. The public see the former. She insists the latter is the truth. The Nkabinde inquiry is no longer simple about Andrew Chauke's fitness to hold office. It has become a referendum on Shamila Batohi's leadership, conducted in a crucible of tension, distrust, unresolved institutional failure. The panel sought accountability. In doing so, they may have inadvertently revealed why accountability in South Africa remains so elusive. This has been the Civic Interest Sentinel, Ndingumqondisi. The inquiry resumes on the 26th January 2026. We'll be watching.